Welcome to another one of our podcasts. I'm John.
I am David.
And we are not lawyers.
And that's the name of our podcast, right?
That is the name.
I'm just confirming for the third time.
Yeah, well, after all the weeks of doing these videos now, we've ended up to call the show We Are Not Lawyers. And any advice that you take from this cannot be construed as?
Legal advice.
As legal advice, correct.
Yeah, I think we're going to border on that today with some of the stuff what we're talking about.
Yeah, okay. So we've got a couple of topics that we're going to cover.
Yes.
Beginning with domestic violence, IVOs, AVOs.
As usual. Just as
well, it's so common these days.
Just as a little aside, I was chatting in one of our, one of the legal chat groups.
Yep. And
I posted, actually you may have posted it, on behalf of the Dads group.
Okay, yep.
Dads Fighting Violence Orders.
Yes.
National group. And we posted in a family law group.
Mm-hmm.
And the post was to do with certain sections of the Family Law Act, specifically 61B and C, and how they interact with family violence orders, like IVOs. And the moderator, who was a woman, said, "How is that useful? How is that useful to the group?" And so there's just been a conversation back and forth. And I was saying, well, this is providing people who are self-represented litigants, for example, some way of understanding what the process is around them, right? And another person chimed in and said, "It's useful to me. I've had allegations against me." And of course, the onslaught of feminist claptrap. There was saying things like, the tone of the post and all these sort of things. So, and I said, well, I'm not really talking about, even though the platform is men's rights, it's really rights that we're talking about, and the vehicle here is men's rights in family law, because so what we're talking about is due process, rule of law, procedural fairness, all of these things. And I pointed that out to the
moderator.
And a whole bunch of people said, "Oh yeah, but your tone." So.
Well, you do come across a little bit angry sometimes.
Well, I am an angry man. What can I say?
Well, to our viewers, we are both self-represented in our cases over the last couple of years. Hence, building a wealth of knowledge that we, share on this podcast. So
and a whole bunch of cynicism.
Lots of cynicism. So yes. All right. So applications in the proceedings.
Yes. Well, no. I want to start at the top there.
You want to start at the top?
So what I've
62L.
Well, firstly, we flagged that we were going to talk about domestic
violence,
and the reason, I went off on a tangent there, as I tend to do.
Yes, you do.
But anyway, thanks for that confirmation. So the purpose.
Should spend a day with him in the office.
You're no picnic, mate. Come on. Now, the reason why I was bringing up domestic violence or DV, such as IVOs, AVOs, etc., is that in family law, it results in certain powers being enlivened, and so we're going to talk about those. Some of those are the powers under 62. And really what we're talking about is how cases are constructed and why specifically men are missing out and how they're missing out. So we're going to talk about a little bit of deconstruction, but not too deep. If you want more information, obviously go to fairincomeLegal.com.au and check it out. So what's first on the agenda there? So
we've got 62L. Which is the first one.
Yep. So we'll talk about, and what is that? That's 62L is the ICL.
The ICL.
Right. So ICLs, an independent children's lawyer.
Yep. I should probably just add in there that here in Victoria we call them IVOs, AVOs, but in other states they're
all sorts
the acronyms that they use there are a little bit different.
Yeah, Queensland, they call that standard male behaviour. No. No, Queensland, they call that a DVO.
A DVO, yeah.
And in WA, they call that a FRO, Family Restraining Order, and everyone else has a similar...
Yeah. At the end of the day, though, the same procedures are in play, and the same, paperwork and conditions and outcomes are pretty much the same in every single state, doesn't matter what it's called.
Yes, this is true, which is the women, the rule of women.
The rule of women, yes. Cool. All right, so let's carry on with 62L.
Right, so when you have one of these family violence orders, that leads to, often enough, the court appointing an independent children's lawyer or an ICL. And the reason they say that is hang on, there's domestic violence allegations. We need to appoint someone who can independently represent the interests of your children. What do you think of that idea just off the bat?
Well, first of all, the key word in all of this is allegations. To begin with, they're allegations. There's no evidence. The court doesn't sit there and scrutinise any evidence that's been put forward, because there never ever is any evidence.
Well, that's a bit harsh. Not that there never ever is. There's
in a family court scenario, there isn't. If there's any evidence, it'll end up in the criminal courts.
I've been teaching you too well.
You have. You have. So yes, so there's a difference between the criminal courts and the family court, and that's where the major distinction is between the two different courts.
True enough.
Now back to the ICL, the independent child's lawyer.
Yes.
The question is, how do I fit with that?
Well, the issue really, in terms of, say, men or your position, if you were going to the family court, is that if, like, the reason that most men will be in the family court, even though mostly it's initiated by women, but that's a separate issue, we want to start to chip away at that. As if a man is filing in the family court, it's most likely because he doesn't have any custody of his kids at all.
Kids, correct.
And one of the issues with having an ICL appointed is that after all of the filing of an application, all the paperwork related to that, there's already a lengthy triage process where they determine what list you're going to be on. And so when we're talking about the appointment of an ICL, the independent children's lawyer doesn't just get appointed and nothing happen. So you can imagine that if you've walked in there and you haven't seen your kids for 3 months, 6 months, whatever
the case may be,
that if an independent children's lawyer is eventually appointed, and you still haven't seen your kids, then that's going to take time.
Absolutely, it's probably going to take another 2-3 months. Because by the
time
time you get the appointment, by the time your child gets to see this ICL, and then by the time they create their report, straight away there, we're already looking at a minimum of 3 months, in my opinion, and in the experience that I've had with other men going through these situations. It's a minimum of 3 months in most cases.
I think that's being
generous.
Yeah, I think so. It's more like 6 to 9 months, and that's why a lot of these cases, so you may not even have interim orders that make any sense. So you'll just go straight to final orders.
Look, and a little bit of advice to men that may be watching this in the future: don't wait for these things to just happen.
No.
You need to be proactive. You need to get out there. You need to, get whatever advice it is that you need to get. But my advice would be, get onto it as soon as possible and get the ball rolling.
Yeah, and just to be more tangible, like when we're talking about things that, we're going to talk about a few other things, but the appointment of an independent children's lawyer, and that's 62, what was it, L?
62L.
And then after that, we've got 62G, which is the appointment of family report writers.
Yeah.
Generally, there'll be psychologists that charge a lot of money, like 10 grand. These things, if you want to bypass that. That's not easy.
No.
And the only way that I'd recommend is that when you're filing, to make sure you've got solid interim orders proposed, and that's the thing that you have to push. So if you are going with a lawyer, which I would not advise, because especially if there's domestic violence involved, or allegations I should say, they are not likely to steer you towards getting an equitable interim order. That's why we exist.
Yeah.
So back to these provisions, 62 G and L, which are for the ICL and these interim report writers. One of the issues that happens is that, I mean, you just talked about time. I mean, it's going to take a lot of time to do these
these reports.
There's reports on one household and then the other, and then they collate their information and they take questions and all the rest of it, and they come up with a general report. And the court sees that, and
would you call that a consensus?
I don't know if it's a consensus. I think that to me, what it is, the way I see it, is just layering. So for example, the base layer might be an allegation, and then on top of that, you might have a breach allegation as well. Who knows? And on top of that, you can have your family law matter. And like I said, if there's domestic violence involved, the court or one of the parties might say, oh well, standard procedures to get an ICL involved. And the whole purpose of the ICL is to have a broad knowledge of all of the issues. And so what are they going to do? They're going to order family, or they're going to ask for the court to order these family court reports and child impact statements, psych evaluations, all of these things. And they all take time, and that's really the one of the points that as to what Fair Dinkum Legal is doing, that other law firms, such as the High Conflict Divorce Centre that we
spoke about the other day, yes.
But they're really to use an American expression, like a dime a dozen. Like this is what the lawyers out there are doing, because it's the what is it?
The path of least resistance.
Path of least resistance. That's right, because this is just like what I would call business as usual, BAU.
Yep.
So
I call it the tick box theory, but
tick box theory. Right.
Tick box theory.
And so many people out there, especially men who may have been messed over from the family court, will think that that judge had it in for me. The ICL didn't represent my interests, and my view. Well, you know what my view is.
Yes, I do. I do know what your view is, and we've had these discussions many times. And I must admit to the camera that I was one of those people who actually thought that the judge had it in for me.
I'm sure. Like I wouldn't have been any different.
Yep, and there's a lot of men out there that think that. Unfortunately, as I've discovered, that actually isn't the case. It is about the system, and the system is actually working as it's supposed to be.
Well, I mean, you could say that's working as designed, and we do as a catchline. But I think that more what I'd be inclined to say is, okay, you've had a decision that you don't like, and there's lots of people who get those. And the question is, what was incentivising the court and these registrars and the independent children's lawyers in general, all of these specialists and professionals, what is incentivising them, and how do we change that incentive? And that's really one of our catchphrases, right? That we say that we want to become the path of least resistance, and the way to do that is to put roadblocks ahead. And it's not really the domain of this podcast necessarily to spell out everything. That's, I suppose, our IP, if you like. But we are trying to educate men and people in general as to how the processes of the court set up. So just below those two, the next one is the key one, I believe.
The orders.
The orders. Yeah, and this is something that even through understanding law in general, and again, nothing that I say
can be construed as legal advice.
No matter how much it sounds like it.
Far from it.
Far from it. These are just opinions of some sovereign citizens.
And maybe one wise old man.
Wise old man? Okay.
Yes.
Okay.
That'd be you.
Oh, Okay, so
Court orders.
Court orders.
Mm.
That even after looking at family law for a substantial period of time, like the last few years, really, that it didn't really dawn on me how critical orders of the court, like once you're in there, it's the orders which are, it's the enactment of all of the procedural mechanisms come out through orders.
Yeah.
And they are the central landing point of everything that you need to know about your matter. And what we know about self-represented litigants is that they are often swamped. They don't understand what the orders are and what they are specifying and why. When they specify that there might be a schedule of documents that needs to be filed, sealed, and then served. All of these things are what we need to understand if we are to sort of take a bit, control back a little bit.
So are these orders written in the term that I've heard being used out there, legalese?
They are a combination of plain English, and this has been a project of some, I think Justice Kirby of the High Court. He certainly advocated for plain English orders and case management and case law. So there's been a lot of push towards that. But having said that, they are very technical in nature. They need to be arranged in terms of a chronology. Because they really do stack on top of one another. You need to understand what they're doing and why, and that's again why we say you need to understand what's going on around you, and the way to do that is to analyse word by word. What is this order asking for? Why is it asking for that? What do I have to do with this order? And are there any things that I disagree with on this order?
Cool. All right, let's move on. Apps in proceedings. Applications.
Okay, so I think that for this is already a fairly long
video.
Yeah, so I think we'll have to wrap this up and we'll have a separate video on application in a proceeding and application for a review.
All right. And then we'll go into subpoenas after that as well.
Yeah, because these really are how the Family Law Act and the procedures and regulations and court practice notes and directions. And again, not legal advice.
No, far from it. Keep saying that.
Keep on saying it because
it'll pop up underneath here as well.
Yes, because I keep on saying things that seem like legal advice. So just to finish that thought, the applications and proceeding, application and review, subpoenas, these are all the mechanisms that
exist within the legal system.
Yeah, this is how the court functions. That's the fact of it. If you don't understand how an application and proceeding works and what its utility is, then you will be at the mercy of a lawyer or legal aid, and we know the horror stories of that, don't we?
We've heard plenty of horror stories about men getting, directed in the wrong directions and, basically incriminating themselves, with the proceedings that they've been put through.
Yeah.
So, and there was no point for it to begin with. All right, cool. So we'll wrap this up today. Give the video a click if you like it, and follow us on our social media platforms. Now, just before we wind up, is there any more updates on our code case called Max?
Max. Well, yes, he's had a hearing in a separate jurisdiction today, which went as expected.
Yep, fantastic.
So no problem there. And I think that we'd need a longer video to
we'll probably do a whole video on Max, but I'm just sort of putting this out there, and obviously he was in court today, and everything went really well, and everything's moving forward.
Everything's moving forward. He's using the procedures of the court in order to, limit the court's ability to make orders that harm him and his interests. His interests are seeing his children. So,
and as I was finishing off saying earlier about how sometimes lawyers don't do you a world of good. Sadly, Max is one of those men. Twice, yes.
Twice over.
Anyways, everything's moving forward for him. So, yeah, everything's really looking positive for Max.
It is, and yeah, we'll hope to have a fairly major,
Another update.
Yeah, I mean he has a hearing in the next few months, we'll say, because we can't because of I think it's Section 114. We can't disclose anything that would help to identify
who he is,
or any party in the case. So he's got a case coming up in the family law court, and will be an interesting hearing.
Yeah, cool. All right, well, that's it from us. I'm John.
I'm David.
See you next time.
See ya.